morning and welcome to today's installment of the AIAC's Diversity in Arbitration Week 2021, organized in collaboration with the Chartered Institute of Arbitrators Malaysia Branch. My name is Shazrin Shafiqi Shahizan and I am a Senior Case Counsel at the AIAC. Today, alongside my fellow co-interviewer, I have the privilege of interviewing Michael Peer, the Disputes Advisory Leader for Southeast Asia Consulting, PwC Singapore, on his journey as a sought-after arbitrator. On that note, I would like to introduce my co-interviewer, Ms. Crystal, a partner at Hishammuddin Allen Gledhill, who will then put forward the first question. Crystal, over to you.
Thank you very much, Shazrin. Michael Peer was originally trained as a chartered professional accountant in Canada. You are a member of the Royal Institute of Chartered Surveyor with a focus on business valuation. You have a master in law and of course is a fellow of our Chartered Institute of Arbitrators. You have been included in independently compiled list of global international experts by the Law Business Research since the inception of the list. And in this particular list, you have been described as a standout name in the market, highlighted as a first-rate expert witness in the commercial and investor state arbitration proceeding, extremely sharp, commercially minded, and very composed under cross-examination. And of course, one of the foremost experts in Europe and now invading our Asia, based in Singapore. Having such an astonishing background in accounting, what inspired you to pursue a career in arbitration?
Thank you, Crystal, for that glowing introduction. I'm a little red in the face after that, but like many, I owe my career aspirations to the leaders, and I say leaders, not bosses, that I worked with early on in my career. I remain in touch with many of them if they're still alive and still consult with them on some of the major career changes in my career. So the first step away from being an accountant and the normal life of an accountant was when I was working for an accountant who was a bankruptcy trustee. And so he had me identifying and then locating and recovering assets for the creditors. From there, it was a very easy step to becoming a forensic accountant, began investigating frauds, and then that led to being an expert witness, initially on accounting issues and valuations, but then on other things, a wider range of topics based on my experience. I then realized, and I had a strong desire to be a better expert. And so I realized to do that, I needed to have a better understanding of my audience, which were the lawyers. So I went back to school so I could become an arbitrator. And so I went and I got my LLM, and then I embarked on becoming a fellow of the Chartered Institute of Arbitrators. So in general, my clients, though, only consider me for very specialist arbitrations, and I'm working to change that mindset.
So your transition is, could I say that your transition is actually quite easy, or is it a difficult one between an expert and thereafter being an arbitrator?
It's actually quite an enjoyable one because sitting on the other side of the fence or the other side of the table. So I know what it's like to be in the hot seat and answering. And it's quite an enjoyable transition to be asking the questions at times.
Right, okay. I think I myself am inspired now to be following your footsteps, Michael. Okay, now, to that end, how did you go about securing your first appointment as an arbitrator, and how did you find that particular experience?
I think, like many before me, my first appointment was a matter of being in the right place at the right time, and having someone who was willing to take a gamble on me. What I realized once I'd had that first appointment was that just like in the accountancy profession, there's a big difference between having the book smarts and actually doing it. And you study hard, you learn all the theory, you pass all the exams, but when you do it for the first time, you realize you have no idea what you're doing. The second time round is so much easier. And I really encourage everybody to keep working on it and being open to different opportunities to learn and to keep practicing.
That's good advice. Just a quick one before I pass it back to Crystal. If there's one thing that you wish someone would have told you during that first appointment, what would it be?
Probably just how intimidating it was going to be, and to just fall back on everything you learned, consult, and push through.
Can totally agree with that. I was like having such a hard time over my first one, and fortunately it was an AIAC appointment, and of course you have a case counsel there to back you up, and that smoothen your journey much more. Next question, Michael, for you. Could you share with us your personal experience in how you have seen professional diversity make an impact in international arbitration in a way that would not have been with only standard arbitrators coming from purely legal background?
So I think one of the stories that always sticks with me about arbitration is that it really dates back to Babylonian times, and that it became a way of resolving disputes between businessmen. Even in Roman times, when it became codified in law, it had nothing to do with the state. There was no lawyers involved in the whole process. It was for those who weren't able to amicably settle their disputes amongst themselves, could present their sides of their case to their peers, and they would get an answer. No lawyers in sight. And I would say it's been a long time since I've been on a tribunal that hasn't consisted entirely of lawyers or people with legal background. But I have seen a hint of the power that having a professional diversity on the tribunal brings. And that's where some of the lawyers have had the deep industry background, and they've been appointed on that basis. And the depth of the questions that they ask, the understanding of the nuances of the industry, and just a general comprehension of the context of the dispute comes through in the questions, and the individual's knowledge is just so obvious.
Okay, Michael, if you had to pick one, and I like to go about choosing by just one, because people can easily focus on one aspect for them to follow your footsteps. If you had to pick one skill that is most important to have as an arbitrator from a non-legal background, what would that be? And would it be a technical, or would it be, like you mentioned earlier, you just have to keep learning?
I think you do have to keep learning, but I think communication is without the most important skill for an arbitrator, be it spoken or written. Someone without a legal background has to get to grips with the legal issues in the case. That you can't get away from deciding on the merits of the issue. And they're going to have to do that through active listening, through questioning, and then they're going to have to be able to express his or her views to the rest of the tribunal and to the participants in the arbitration, using their terms and their logic. So being able to cogently express one's train of thought and the logic behind one's views is critical to being a successful arbitrator.
Let me pose a hypothetical question to you. I'm currently representing an independent power producer in international arbitration. And of course, we have commercial disputes which require a quantum expert. So my question to you is, should I encourage my client to engage you as their expert witness? Or maybe I should encourage them to engage you as the arbitrator? What would your advice be, and why?
It all comes down to what is the nature of the dispute. And if the legal arguments are relatively clear-cut and the focus is more on an industry decision around how the contract gets interpreted within the context of the industry, or if the more of the dispute is around simply how much is the quantum of the damages, then I'm probably more useful on the tribunal deciding that part of it, because I can understand, I can draw in all of that information. Because the alternative is that you then get a tribunal appointed expert in addition to the party-appointed experts, which just increases the costs.
And maybe I put it the other way around. Do you prefer to cross-examine an expert witness or be cross-examined or hot tub by a counsel?
I think the real question there is, what is the hot tub? And so I've had hot tubs where it really has been the experts cross-examining each other. And I think that has been an incredibly powerful way of getting a true understanding of the issues in front of the tribunal, to let the experts talk amongst themselves and let the tribunal ask for clarifications. Where hot tubbing has gone recently is it's simply the two experts answering almost simultaneously the same question. And I think that has its own merits and its own power, but I think there's more that can be done with hot tubbing. But back to the gist of your question, which is, do I enjoy the thrust and parry on the receiving end or on the asking end? I think that actually they're equally challenging, because in order to come across and get the intent of your responses to come through, you need to be very clear either side of whether you're asking the questions and the logic of that, as well as how you respond to them.
Indeed, and that would be a class act, because you would want to cross-examine that particular expert witness without having them knowing that what are you really asking, and throwing to the other side expert witness and trying to get an answer that you wish to. I'm sure you'll be able to do that like just as good as the expert witness, because you are yourself one of them, right?
I think that I won't say that I am a very good cross-examiner, because I haven't had the practice and the time experience that a lot of the cross-examiners that I come across have had. But I think you're right, I have a slight advantage because I understand the topic.
Michael, what sort of insights or perspective do you believe those from non-legal background can bring to an arbitration?
So I think there's been a great deal of discussion about diversity generally in the ADR field. And there's been so much done recently around improving gender diversity as an obvious first step in the process. But to an extent, that's actually limited the discussion about diversity of other forms. And that still needs to be addressed. So users of ADR that I'm seeing from the surveys and the discussions are often more focused on seeking diversity in thought and experience, which brings about a robust analysis of the problems and well-designed solutions as a result. So to achieve this diversity, we need to build upon the gains that we've had in gender diversity, but to ensure that the users are getting the most that we can give them from diversity generally. So we need to extend that conversation into areas beyond gender, into ethnicity, into education, into experience, to bear on the issues that we're being asked to resolve by the users. And I think all forms of diversity are deserving of the efforts that have been made to promote gender diversity. And the more we expand on our commitment to diversify, including formal training that arbitrators rely upon and things like that, the more reliable our decisions will be for our users. So I'll give you an example of this. Some of the best forensic accountants that I've come across and I've worked with have had backgrounds in science. And that's because a core part of the scientific training includes laboratory work. And that requires them to formulate a hypothesis and then to test their hypothesis through carefully controlled experiments and to document the factors that impact the outcome and things like that. And these individuals bring that, come to forensic accounting with that rigor of analysis and an approach to investigations, which is extremely valuable and a complementary skill. And I think when we get more educational diversity coming into arbitrations, we'll bring that rigor and that diversity along with it.
Thank you. That is such a pointed advice. just wondering, because the Chartered Institute of Arbitrators and also the Asian International Arbitration Center, they have put in a lot of effort to encourage professional diversity. Just include what you mentioned above earlier, in relation to educational background or even experience. And my question to you is, how can we convince more people from other professionals to bring their experience to international arbitration?
I think one of the things is that individuals need to realize that this is something that they can do. So I think a lot of people haven't really thought about becoming an arbitrator. They think that it's something that is a role for retired judges, for retired lawyers. So many people, for instance, didn't think that it was possible to earn a living playing video games or blogging about their lives. But we've seen that people can live the lives they want to doing that. So it's definitely possible to become an arbitrator from any walk of life if you're prepared to work at it. And so the diversity initiatives from the AIAC, goes a long way, I think, to helping people realize that, they can reimagine the possible.
Okay. Thank you for that, Michael. To echo what Crystal had mentioned earlier in influencing more people to join arbitration from various aspects of their careers. But before that, I think we need to explore, what sort of challenges that these individuals should consider, especially those from non-legal backgrounds. And perhaps you can briefly explain some of the challenges that they may be facing and what sort of methods they can do to overcome these challenges.
Thank you for that question. I think the answer to that is partly in that the conduct of arbitrations has become just as contentious recently as any litigation has become. So, as an indicator of this, the ICCA I saw has just recently published a rules of conduct, or a set of rules in order to restore decorum in the conduct of arbitration proceedings. So I think my first thought to people or comment is to make sure that you are up to the rigors of the job before you're applying for it. For those who are possibly hesitating or sitting on the fence, my suggestion to you is go for it. It is a hugely rewarding job. And that's why so many continue to do it long into retirement. PwC's purpose is to create trust in society and to solve important problems. And being an expert witness and being an arbitrator has allowed me to do both of those things. But keep your expectations in check. Start being an arbitrator part-time initially, and then work up from there.
You mentioned that reimagining the solutions and also helping parties to find a solution. Would it be possible or easier for an arbitrator coming from non-legal background, more in tune to the actual dispute, the gist of the disputes, to be able to mediate a solution through an ARB situation when now we're increasingly promoting mediation as perhaps an alternative dispute resolution method?
I think you're going to see increasingly that you will have a mediator who is very good at mediating, will be doing co-mediation with people like myself who are familiar with mediation, but have an industry or a technical background to assist the mediator in understanding and to assist the parties in coming to a resolution.
Okay, Michael, before we end or conclude the session today, I'd like to ask your opinion. What are your thoughts on such initiatives, for example, as the AIAC's Diversity and Arbitration Week, in promoting professional diversity outside of gender, as you mentioned earlier, in international arbitration?
I think it's a wonderful initiative. Many of the professionals that I meet in the course of my work have never even considered being an arbitrator. And again, they see it as a role for retired judges or retired lawyers. So I think that people need to reimagine the possible. And if they're at all inclined towards sitting as an arbitrator and helping people resolve disputes that have not been able to be resolved in any other way, then this is a hugely rewarding opportunity for people.